This is an overview of the study guide, and so let's start with question 1 first. Here I'm asking you to explain the difference between proscriptive law and prescriptive law. And remember that proscriptive law is something that tells us, a law that tells us what not to do. And so make sure you give an example or two of what laws you know of that tell us what not to do. And prescriptive laws are laws that tell us what to do. So make sure you give an example or two of laws that tell us what to do. So you can think about, the seatbelt law, the helmet law, when you ride a motorcycle. Those are prescriptive laws. When you think about proscriptive laws, you can think about things such as don't commit murder, don't commit theft, etc. We have lots of different laws that tell us both what to do and what not to do. Explain the 5 components of a crime, and if you look at page 116 in the text, you see that there are 5, and so make sure that you list all 5. And I want you then to discuss the difference between crimes against public order and crimes against morality, 2 different kinds of crimes. I ask you then at the end of this question, are there any crimes that you believe are victimless? Okay, are there such a thing as victimless crimes? And there's a discussion in the text about that, not controversy, but that disagreement in society about whether crimes such as prostitution, drug dealing, etc., are those truly victimless crimes? Is there really anything such as a victimless crime? So that's question 1 from chapter 5. Question 2 from chapter 6 asks you to define a search. According to the legal definition, what is a search? What constitutes a search? And then explain whether people have a reasonable expectation of privacy when walking down the street. If you remember in chapter 6, this chapter has a lot of focus on what is a reasonable expectation of privacy in society. Do we have a reasonable expectation of privacy in our homes versus when we're driving around in our cars, etc.? And in this particular part of the prompt, I'm asking you to think about when you're walking down the street, do you have a reasonable expectation of privacy? Why or why not? Explain to me. Then the next part asks you to explain reasonable expectation of privacy. Explain how reasonable expectation of privacy is viewed by courts according to Katz versus the United States, in 1967 Supreme Court decision. You'll remember that this is the case in which Mr. Katz was using a phone booth on his street to make calls, and apparently federal agents knew that he used that phone booth quite a bit. They wiretapped the payphone, and of course they heard Mr. Katz engaging in the commission of crimes in his conversations. And so this went to the U.S. Supreme Court with the key question being, did Mr. Katz have a reasonable expectation of privacy when he went to the telephone booth down the street from where he lived? And if you recall, the court decided that yes, he had a reasonable expectation of privacy. And remember, the test is 2-pronged. The court said that not only there's the subjective piece, does the individual have a reasonable expectation of privacy? Certainly Mr. Katz had that reasonable expectation of privacy. He was using a phone booth on the street. How many of us think that something we use that's public is being bugged? Whether it's the restroom in our favorite restaurant or on campus at school. We usually think we have a reasonable expectation of privacy when we're in a bathroom stall. At least, nobody's going to look over or listen or whatever. The second prong, though, is does society also believe that a person has a reasonable expectation of privacy? And so it's not enough just to have the subjective, like the person, the individual expecting to have privacy, but does society also think that generally you would have privacy? And in the Katz case, the U.S. Supreme Court said, yes, that was a reasonable expectation of privacy. The next part, how did Miranda versus Arizona change how law enforcement, correct this really quickly here. How law enforcement officers arrest suspects. Under what circumstances are the warnings not required? Okay, so you recall that Miranda versus Arizona is the case in which the man by the last name of Miranda was questioned for hours on end. He spoke very little English. He was fluent in Spanish. However, because he was questioned for many, many hours and he wasn't fed, he wasn't allowed to go to the bathroom, etc., he signed a confession in English, and he was convicted because of that confession. On appeal to the U.S. Supreme Court, the court found that our Sixth Amendment rights don't really mean anything unless we know about them. So Miranda did not know that he had the right to have an attorney. Miranda did not understand that he had the Fifth Amendment right to remain silent. Miranda did not understand that anything he said could and would be used against him, etc. And so this is a key case that law enforcement officers have had to operate under since 1966. And so make sure that you flesh that idea out about what the court decision was about. And then the last part is, under what circumstances are the warnings not required? Okay, so there are some circumstances when law enforcement officers do not have to provide those warnings. And so make sure that you see those in the text. And then I ask you finally, do you agree with these exceptions? Do you think these exceptions are correct, are good exceptions to have? Because of course, there are times when, because there's an exception that applies to the warnings being given, the officers may catch, quote, a person engaged in crime, and maybe you think that's a good thing. Maybe you think that it's not. What's your idea? What's your opinion? Just explain it to me. Question number 3 from Chapter 7 here. Explain in detail the differences between criminal and civil law. Of course, huge differences. Criminal law, you have to have 12 juries. In many jurisdictions in the U.S., in the civil cases, you can have as few as 9. And of course, in a criminal case, it has to be a unanimous decision by the jury, and in civil law, it can be a split decision, just as long as the majority finds a particular thing. And so there are other differences as well. Of course, the difference in the level of burden of proof. In criminal cases, it's beyond a reasonable doubt. In civil law, depending upon the state, it might be preponderance of the evidence, or it might be clear and convincing evidence. Remember, make sure that you're fleshing out all of the details of those differences. Explain tort law and discuss the 3 primary categories of torts. Tort law is a fancy word. We usually just say personal injury law, because tort law deals with personal injuries to a person or to their property sometimes. And the 3 categories are ordinary care, causation, and strict liability. And again, I know that this is not law school, so I don't expect you to understand all the intricacies of these 3 things, but the general idea. For example, strict liability. Strict liability is that idea that it doesn't matter whether the plaintiff, the person filing the lawsuit against the defendant for damages, it doesn't matter in a strict liability case whether the plaintiff was partly at fault. Because in strict liability, it doesn't matter. All that matters is that the defendant who is being sued is strictly liable for whatever happens. Okay, strictly liable for whatever damages. And then a different thing, different kind of case, causation. For example, in a car accident, causation is a big concern, because it may be that maybe one person rear-ended another person. However, if the person who was rear-ended didn't have working brake lights, then that also means that the person who was rear-ended, we'll call that person driver A was partly at fault for not having working brake lights. So maybe the driver B, who crashed into the back of driver A, isn't fully at fault because there were no working brake lights. So who is at fault in causation cases is a huge part of what a jury or a judge will decide. Because that will, of course, if the plaintiff was partly at fault, well, maybe the plaintiff doesn't get as much money as they were hoping. And then ordinary care. The idea that did someone do what he or she should have done in the course of ordinary care? Meaning that ordinary care is this idea that people do what they're supposed to do and don't act recklessly or negligently. So here's a common tort case when we think about ordinary care. A surgeon who performs a surgery and accidentally leaves a pair of, a scalpel, well, maybe not a scalpel, that would probably cause great internal damage, accidentally leaves a pair of scissors or some forceps in a person's body. And it isn't until the person is recovering that a follow-up x-ray is done and oops, there's a pair of scissors there, or there's a set of forceps there. The doctor left them in. An ordinary care tort action would be one in which the patient could sue the doctor because the doctor lacked ordinary care. The doctor did not ensure that all the utensils or all of the surgical instruments that were being used were removed. So again, just give the general idea. You don't have to know all of the intricate little details. That's for law school. Also explain the defenses to liability, comparative negligence versus contributory negligence. Okay, so those are some defenses. Finally, based on the discussion in the text, do you oppose or support tort reform? Remember, I had you do a discussion on this idea when, well, actually, that was about arbitration. Tort reform. Tort reform is different. You might recall there's a discussion on tort reform on page 176 in the textbook. And really, tort reform has been, again, I don't want to say controversy because it seems to come and go. The discussion around tort reform ebbs and flows depending upon what else is going on in the U.S. But the key question is, insurance companies, as well as people who are being sued on a regular basis, doctors, for example, dentists, etc., they want Congress to put a cap, a limit, on how much can be obtained through a tort lawsuit. And of course, there are some people who believe it's a great idea because medical malpractice, dental malpractice, legal malpractice, all of these types of insurance are quite expensive. And if you are a practicing lawyer, doctor, dentist, you would be probably considered stupid if you didn't have that kind of coverage, insurance coverage, because at one time or another you're probably going to be sued. But it's very expensive. And so the other side of the coin is, much like with arbitration, in that discussion I asked you to do, people shouldn't be limited to what they can obtain if they are hurt in a personal, if they suffer some sort of personal injury at the hands of the doctor, dentist, or lawyer. And so read through that and think for yourself about whether or not you think tort reform is a good idea, and make sure that you explain your opinion. Finally, explain the history and philosophy of juvenile justice in the U.S., and I tell you here to make certain to discuss the concepts of childhood and the child savers movement. So it's a pretty lengthy history, so at least focus on the history, and you can start with the idea of childhood, child savers movement, and then focus on, here in the U.S., the philosophy of juvenile justice, why the juvenile justice system was started. Because remember, early on, kids were treated or were processed through the same criminal justice system as adults. And there came a point in the United States in the late 19th century when people began to think that maybe we shouldn't do that, and that the first state to create a juvenile justice system was Illinois in the late 1890s. Then pick 3 cases that extended due process rights to individuals, and there are 7 of them to choose from, so just choose 3, and discuss the case fully and explain why the court held that it was important to extend these rights to juveniles. Because prior to these cases being decided, juveniles really didn't have many rights. And so it was those rights over time with each case were expanded. Now, if you recall in the reading in this chapter, juveniles, though, do not get a right to choose a jury trial. All juvenile cases are decided by a juvenile judge, a judge who's assigned to juvenile courts, so a juvenile justice judge. So I ask you here in this last part whether you think juveniles should be allowed to choose a jury trial. One of the key reasons why many people argue that we don't do it, and it's a good thing not to do it, is because these are juvenile cases, and consistent with that idea, we do not publish the names of juveniles who are charged with crimes, because the hope is that they're going to be able to be rehabilitated, and we don't want them to have the stigma of having had a court case, right? So many people argue if we allowed jury trials, then we would have to end that kind of anonymity for juveniles. So there's something to be weighed there. So what do you think? All right, that's it for the overview.